Hi, I'm Jim Gabe, founder of Citizen Arts. Welcome to our second episode of In Their Words, What Public Officials Do for Us. This series takes a close look at the vast range of people who serve us daily at the federal, state, and local levels. It certainly matters we understand what they do. Their actions affect our lives in large and small ways every day. If you haven't listened to our first episode, please do. It's a candid, informative, and sometimes provocative discussion with Steve Hobbs, Secretary of State of the great state of Washington. Turns out, secretaries of state do far more than certify elections. For example, tracking and fighting cyber misinformation. Today, we turn our lens to the courts. If you've ever been a juror or a litigant in a lawsuit, or been glued to Law and Order or other TV dramas with courtroom scenes, you've seen who presides over it all, the judge. Citizen Arts is honored to present a conversation with Justice Adrienne Grover, a self-described nonjudgmental judge. Her words speak definitively and inspiringly in a time of mounting misinformation, distortion, and hyperbole aimed at the role of law and our judiciary. Justice Grover's journey has taken her from an undergraduate major in linguistics to sitting on the bench of California's 6th District Court of Appeal, part of a legal system that sees the largest number of decisions appealed to a state Supreme Court and to the U.S. Supreme Court. In her 20-plus years serving in multiple judicial roles, Justice Grover has overseen cases of great diversity, from land use to water rights, criminal law, and labor negotiations, to drug treatment, juvenile mental health issues, and personal injury litigation. One of her takeaways from a lifetime career in the law: you are confronted with so much humanity in each case, and you come away with such a deep appreciation for the human condition. You'll find her full bio in the show notes and at citizenartscreative.org. And now to Justice Adrienne Grover in her own words. Hi, Adrienne. You are such a busy person. We're so gratified you're taking the time to join our discussion.
Thank you so much. I just think it's such a great idea for a program. It's really my pleasure to be invited. Thank you.
Let's get right into it. You have a BA from Berkeley in linguistics. How did you go from linguistics to deciding you want to be in law?
Well, I was fascinated to do that as an undergraduate, but then comes your senior year and you have to think about, are you going to pursue it further? I'd always had a commitment to social justice issues and a desire to help people and do something meaningful and practical. So law school seemed like a logical pursuit. And indeed, I really loved it. And it was a natural progression from a focus on language and logic to utilizing it in a very practical way that helps people.
Was there anybody in your family with a law background that inspired you?
My father was a lawyer. And
Oh,
I watched him work throughout his career and thought growing up, I am not going to be a lawyer. I would talk to him about it and expressed that I was not interested in law school and there were too many lawyers anyway. And he said, have an open mind about it because I think you'd be good. I think you'd be interested in it. And indeed, I really liked it.
I'm curious whether you recognize things about your own personality that would lend themselves to a profession in law.
I'm very detail and language oriented. And so that certainly fits well with my work on the Court of Appeal. In addition to that, I am pretty even-keeled and open-minded, flexible, and maybe ironically, not judgmental. You would think, as a judge, you have to judge all the time. But I think one of the most important attributes is not judging and just being there to ensure that there's a fair process, that everyone's treated appropriately, has their day in court. You're not ultimately there to pass judgment upon the individuals appearing before you.
A non-judgmental judge. That sounds like a good ideal. And if you put it into practice, all the better. You started in private practice at a San Francisco law firm, and you decided to move into the public sector of the law. How come?
I desired a close connection between my work and my community. And although working in a firm was interesting, good training, good colleagues, pays well, I really wanted that closer connection between what I was doing day in and day out and effects on the community. I was fortunate to get a job in a county counsel's office and loved it, never looked back.
One of the things I found really fascinating going through your background is the number of legal areas in which you immerse yourself. I'm going to just read this, what I have gleaned here. Land use, water, taxation, criminal law, family law, drug treatment, court, juvenile dependency, mental health. That's a lot to learn about.
I will say one of the things that I really value about my job is the diversity of the issues that you encounter. And that's true in law generally. Every case has its unique issues. That array of issues is partly a reflection of working in the public sector as a lawyer, because in a county counsel office, you encounter everything from defending the county in a personal injury lawsuit to protecting the county's water rights, advising the Public Works Department about getting an easement to put a culvert under the road, to advising the Animal Control Department about something, or the tax collector, labor negotiations, just everything. It's an amazingly diverse practice that puts you front and center with what's important to your neighbors and your town.
Okay, so you're doing this what I would call very close to home kind of work. And at some point, the word judge entered your mind in a different way, not going before a judge, but how did it come about that you started to think about yourself as a judge?
I had to go in to one of our local judges to get an order signed. He looked at it and signed it, and he said, by the way, I'm going to be putting in my notice of intent to retire, and I think you should take my place. I really, really enjoyed my job and thought I'm going to be one of those county councils who serves for decades. But he put the idea in my head, was very encouraging. And so indeed, I decided to put in my application to the governor. And I think it was probably about 6 months later, I actually was appointed.
So did he say to you, Counselor Grover, I think you should be interested in this position because? Do you recall what he said to you about you that piqued your interest?
I don't recall specifically, but I think it may relate to my role as county counsel, where you get to wear the white hat and say, I'm just here to make sure that the law is followed, as opposed to being necessarily on one side or another side. I think maybe his perception was that I had a reputation in the community for being fair vis-a-vis people and hopefully relatively easy to work with. Maybe he was looking at that as thinking, well, those are good qualifications and qualities to have in somebody on the bench.
And so you sought and were appointed. How does that happen? How does one actually become a judge?
Different states do it differently. In the state of California, state judges are technically elected. And I say technically because most of the time, the people are actually appointed by the governor. If someone retires at some point during their term, the governor has the ability to appoint someone to fill the remainder of that term. And then at the end of the term, the person is up for election as an incumbent. They might be challenged or they might not be. And if no one runs against you as a judge, you get another term. More often than not, no one runs against the incumbent judge. I put in my application to the governor's office, and that is a pretty arduous process. They don't want to appoint someone who is not going to do a good job. They don't want to appoint someone who's going to reflect poorly on the governor. And there's also a process in California called the Commission on Judicial Nominees Evaluation, referred to often as the Jenny Commission. The governor, before appointing someone, has to send the name to the Jenny Commission. And that commission sends out questionnaires to 100, 200 lawyers in the community, and they give a rating of the person, and they give that confidentially to the governor.
Something that I think a lot of people would probably wonder about, I know I always have, what is the line between appointment and politics and being a judge?
In legal circles, sometimes we say, oh, you have an ethical wall between yourself and someone, for example, in your law firm who has a conflict on a matter you're working on, or an ethical wall, as you're saying, between your role as a judge and the politics of the governor who appoints you, and politics surrounding maybe some of the cases that you're dealing with, and what elected officials might want the outcome to be or not be. That is an extremely important principle. And I would refer to it, and many people do, as the independence of the judiciary. One of our foundational principles is that the judiciary and the judges are completely independent of anyone who might put them in office or threaten to kick them out of office or do something to them. And I'll point this out. In our Constitution, to further guarantee independence, the legislature cannot make any changes to a sitting judge's salary during that term. You can imagine, without a provision like that, the legislature could come along and punish judges, say, oh, really? You're going to decide the case in this way? Well, we're going to reduce your salary to zero. That kind of thing can't happen here.
But there's so much divisiveness in the country, and it's in the news all the time, going, of course, right up to the Supreme Court, that certain judges are expected, or it's anticipated, will vote a certain way based on maybe their personal biases, ideologies, whatever it might be. And indeed, we see that happening, and it's reported also at the state level. What is your view on whether there's been a tarnishing of judicial independence vis-a-vis the political system, and whether you have experienced any kind of pressures in your own judicial world as a judge?
I have not experienced pressures, although I will tell you that sometimes you're called upon as a judge to make decisions that you know are going to be extremely unpopular. Wherever the law takes you is where you have to decide the case. Otherwise, what are you doing? What's the purpose of having a judiciary and courts if in any given case, someone's not going to follow the law? I mean, that has to be fundamental. That is really an ethical principle of judging that says, you have to be so committed to the rule of law and to doing what the law requires that you are willing to give up your job for it, essentially, because maybe your decision will be so unpopular that someone will, at the next time you're up for election, run against you and say, well, we can't have a judge making a decision like that. I'm going to run against this person. We see that sometimes in our national discourse. People say, oh, well, this judge was appointed by so-and-so, and so they are going to go along with them. And we do see that that's not the case. Courts and judges say, well, I was put on the court by that person, but that doesn't mean that I'm an extension of that person for purposes of deciding cases. I'm going to decide the case based on the law. Of course, judges have personal ideologies, philosophies, backgrounds, experience. You have to set that aside once you become a judge. But we can never really completely rid ourselves of our personal philosophies. We can do our best, but some people are going to be a little more liberal than others, a little more conservative than others. That's just the nature of a human institution. If every judge tries to be aware of personal biases and work hard to set them aside and really be neutral and follow the law in the case, then that's the way our system was designed. And I think for the most part, we succeed very well.
Boy, that's beautifully said. You talked about the fact sometimes you have to make decisions that you know are not going to be popular. Can you think of a case that caused you particular anguish because you knew that, yes, you were following the law, you were doing it the right way, but was going to antagonize?
I have had some higher profile cases where there's a lot of community interest, and yet the community is not necessarily sitting in the courtroom and hearing all the evidence. They're one step removed. Maybe they're reading about it in the newspaper, seeing it on the news. So they have a more superficial understanding of the facts, or maybe they had direct experience with the facts and they're judging it on that basis and not according to maybe what the fine points of the law are or what the real legal issues are. Sometimes when that gets translated to the courtroom, it can seem like there's a big disconnect between the decision and the outcome in the case versus people's initial reactions. One case that comes to mind was a very serious vehicle collision with fatalities that blocked the road for hours and hours. Young driver who was intoxicated got into a head-on collision with a family. The best friend of the driver was killed. The mother of the family in the other car was killed. Lots of injuries. The driver was a juvenile at the time, 17 years old, and had had a DUI the year before and had told the court at that time, oh, I've learned my lesson. I could have killed someone, and then continued to drink and drive and did kill two people. So just based on those facts, of course, people are thinking, this is outrageous and she needs to be dealt with in a particular way. I heard all the evidence and then looked to the statute that prescribes the questions that you have to ask and answer about whether someone should be treated as a juvenile or an adult. Ultimately, I decided she should still be treated as a juvenile. Members of the community at large were necessarily concerned. I mean, they said, well, wait a minute, here she effectively murdered two people and is only going to be punished until she's 25 years old, as opposed to maybe a much longer prison sentence. Our administrative office at the court called me and said, we just want you to know that we're getting a lot of phone calls from people asking when you're up for election. Ultimately, I didn't have an election challenge. Once people understood the law a little bit more and the sentencing, and people in the legal community came out in support of the decision because they did understand the precise legal issues at play, everything died down.
And apparently, many people noticed you were doing what you had to do because it was the right thing to do. And that brings me to 2012, when you became a judge in California's 6th District Court of Appeal. And that's a big deal for many reasons. I'm going to go through a few. Your district covers a huge area. It's based in San Jose. It has a jurisdiction in Santa Clara, San Benito, Santa Cruz, and Monterey counties, and very diverse population centers from rural to urban. The court that you're a member of decides more than 900 appeals and disposes of 500 written petitions annually. Due to the huge caseload, the California Court of Appeal sees the largest number of decisions appealed to the state Supreme Court and the U.S. Supreme Court. You are very busy people. How did that appointment come about? And we'll then get into the specifics of what an appeals court justice does.
A person on the court was retiring and encouraged me to apply for the vacancy. I don't want to give your listeners the impression that, oh, it's always an inside track and you have to know somebody and that's how, you get a judicial appointment. Far from it. There's a lot of encouragement for many people to submit their application. I did put in the application there. The Court of Appeal really is what we call a court of error, meaning if someone thinks that something was not done properly in the trial court, they have to say that in the trial court. And then any objections that they've made or preserved there.
This would be the attorneys making these points.
Right. Or the parties themselves, if they're representing themselves, if they're appearing without an attorney. You have to object to what you think is wrong in the trial court, because otherwise you've forfeited the opportunity to challenge the decision on that basis as a general rule. So anything that you think was a mistake in the trial court, then you bring it to the Court of Appeal. And
How does that happen? How do you bring it?
after you get a final decision from the trial court, you have 60 days to file a notice of appeal. It tells the trial court and the court reporter, oh, you have to make a formal transcript of everything. You have to assemble all the documents and the files in this particular case and put it together in what we call a clerk's transcript. So all the papers that were filed in the trial court, those get prepared. And then that gets to the Court of Appeal. And then the person who's appealing writes their opening brief. But sometimes they're not very brief. Sometimes they are over 100 pages long, but they file the written description with all the law that they think supports their case to say, here are the mistakes that I think were made in the trial court, and this is why the decision should be reversed, go in my favor. But then the other side, who prevailed in the trial court, they get to submit their responsive brief that says, no, there was no problem here. Everything was absolutely correct according to the law. And then the appellant gets the last word with their reply brief. They get to say, oh, I'm still right, and this is bad law or old law or whatever.
Is there in-person testimony?
No testimony.
So you're not in a courtroom.
We are in a courtroom at the very end of the process, but that's just for oral argument. And so where you might have a trial that lasts a month, and you might have a series of issues that you want to bring up on appeal, and you write a lengthy brief about them, and the other side writes a lengthy brief, and you have all the paperwork and all the record. Then you come to the Court of Appeal and you can argue your case for probably 15 minutes. That's just the lawyer. There's no new evidence, no new testimony. It's just the lawyer arguing maybe some fine points or there to answer questions. That's a very important part of oral argument, is sometimes once we've read all the briefing, we have questions.
You say we. Is there more than one judge here?
Yes. In the trial court, you have one judge, and we picture that from movies and television and whatnot, and they're controlling the proceedings, and you have the witnesses and the lawyers come in, and maybe you have a jury, and they're to decide what the facts are. In the Court of Appeal, we work in what's called a panel of 3 judges. In any given case, you need 2 of those judges to decide, which way the appeal is going to go. You usually have all 3 agreeing, but sometimes one judge will dissent.
And can there be an appeal of the appeal?
In every state, there are 3 levels of courts. There's the trial court, an appellate court, sometimes called an intermediate court, and then there's the Supreme Court. The Supreme Court in California has 7 members, and they get to decide which cases they take. And with 7 people, they could not possibly handle every question that someone wants them to handle. So they get to decide the cases that they take based on, is this an area of the law that there's disagreement in, and we need to definitively say what the law is, or maybe it's a new statute that's being interpreted different ways, and they have to say the way it should be interpreted, or somehow the law is evolving in the area, and it's time to make a statement about what the law really should be in the area. So they get to decide that. But the intermediate appellate court, my court, we are what's known as the last appeal of right, meaning we take all the appeals. If you appeal from any of those 4 counties in my district, we have to decide every appeal that is properly taken from an appealable order. And we have to issue a written decision on every case, explaining what we see the law and the facts are, and why we reach the decision that we do.
And this will explain why there are appeals court judges spread through the state, covering various jurisdictions.
Right. There are 6 appellate districts throughout the state. And they are divided somewhat with an eye toward distributing the appeals in the state according to population and geography. My court, for example, has 7 justices, but other courts, the 2nd District in Los Angeles has many more justices, and the 1st District in San Francisco, many more justices. And that's according to the volume of cases that are coming up through the trial courts to the courts of appeal.
Is there a grouping, a package, if you will, a category of usual types of cases that come before you?
In the Court of Appeal, you see everything. In our court, I think probably about 60% of our appeals are in criminal cases. That means there's been a felony conviction and someone believes a mistake was made. And then in the civil cases, they can range from family law, environmental law, business disputes, insurance disputes, employment disputes, anything that's non-criminal comes to us also. The typical criminal case, as I say, involves a felony conviction and often a jury trial. There are maybe disagreements about whether the instructions to the jury were correct or whether there was enough evidence to support maybe the verdict that the jury reached, or maybe that the trial court didn't exercise its discretion properly in letting in evidence or keeping out evidence, or there's maybe a sentencing issue that was correct or incorrect.
Are there criminal cases you do not take?
Currently in California, appeals of death penalty cases are automatic appeals and they go directly to the Supreme Court.
I want to get a sense of what the steps of your work process are, what they involve to bring an opinion from the panel.
Once the briefs are completed, then the case is assigned to one of the justices as the lead judge on the case.
Who makes the assignment?
The presiding justice of the court makes the assignment. It is typically done at random to evenly distribute the caseload among all the justices. The justice who is assigned as the lead on that case will work through the briefs with the assistance of research attorney staff and look at the issues and analyze it. The other judges on the case also read the briefs and analyze it. And typically there will either be some kind of memo exchanged among the judges or maybe even a draft decision exchanged to see if everybody's in agreement or not, or how things should be explained or where the issues are. And then the matter ultimately is set for oral argument. Now, people don't have to argue the case. They can say, I waive oral argument. I just want to submit the case and get a decision. And that's fine too. And we will hear anything that they want to highlight from their briefing or their position, and they're available to answer our questions.
Is it the case that the only time you're eyeball to eyeball with the people bringing the case before you is when it goes to oral argument?
At oral argument, we are eyeball to eyeball with the lawyers in the appeal. Every once in a while, an actual litigant will come and attend the argument and hear what the judges have to say or hear what their attorneys have to say. That's fairly rare. Each side gets 15 minutes to argue their case, and then it's submitted. Then once it's submitted, we have to issue our written decision within 90 days.
The interaction with the lawyers then is very different from a trial court in that you won't have sidebars. You won't be calling a lawyer up and say, don't go there, don't do this, don't do that. They're speaking just to the arguments they've already presented in writing.
That is true. One of the distinguishing points is that the Court of Appeal, boy, everybody is on their best behavior. You don't have anybody, saying, oh, I'm going to hold you in contempt or move on, counselor, or stop. There's a great deal of professionalism and civility in the trial courts. And so I don't mean to give the impression that, the trial courts are not that way. But there is more room for emotionality in the trial court. People do get very impassioned there. Whereas in the Court of Appeal, we're not examining witnesses. We're not performing in front of a jury. We're just there to talk about the legal issues.
Are there time frames generally on how quickly this has to be adjudicated?
Typically, It takes a while for the record to be prepared, and then the attorneys need time to prepare their briefs. Once that's done, really it should come to a decision within 9 months.
Thinking about the various things you have done and do now as a judge, what's the biggest challenge for you from a career point of view?
I think one of the bigger challenges, which is also one of the things that makes it rewarding and also keeps things so fresh, is having to really get up to speed on new legal issues all the time. Every case type is different. When you're in the trial court and you change assignments, all of a sudden you're working one day in criminal law and the next day in family law or the next day in civil law. In California, we have a very, very robust judicial education system within the judicial branch. You have lots of classes and opportunities to learn about your new assignment, to stay fresh and learn new areas of the law and be competent enough to render decisions in those areas.
I was reading your local paper that there is increasing diversity, if you will, in terms of gender and race and ethnicity amongst judges in the system. Is that what you've experienced?
I'm glad you brought that up. There's been a concerted effort over at least the last 10 years to make the judiciary in California more closely reflect the population of California. And I think it's been hugely successful. There's been a lot of outreach to people. Maybe they're lawyers and they appear in court and they say, I don't look like that person on the bench. I don't see myself as a judge because I am not a white man in my 50s. There's been a lot of effort to reach out to those people who don't fit that demographic and say, yes, you can be a judge too, and it's very important. And I want to emphasize there has been absolutely no compromise on qualifications to make the bench more diverse. The judiciary really should be more diverse and should include more women and more people of color and more different ethnicities because it both reflects Californians and court users and brings different perspectives into judicial decision making. When I came to the Court of Appeal 10 years ago, of the 7 justices, I was then the second woman. We are now 5 women and 2 men. The California judiciary is measurably more diverse than it used to be, and I think that is a very positive thing.
You have dedicated your professional life, and I'm sure big hunks of your personal life, to the pursuit of the law. What has been your biggest gratification in doing so?
I have been so lucky to have a fascinating career and a rewarding career in many ways. I think the biggest gratification has been my ability to work on things that directly affect people's lives for the better. That could be in deciding a particular case or helping people reach a settlement in a very difficult case where everybody feels like they can walk away and live with the result. Sometimes it's been in very small ways that you don't really expect. For example, working with people in criminal cases. I had one gentleman in my court who had a long history of criminal convictions. I had to send him out to restore his competency so he could participate in the case. The next time I saw him, he was lucid, he was articulate. He said, I didn't know what was going on with me, but now I have this diagnosis, I'm being medicated, I can completely control my actions, I can go out, get a job, support myself. I mean, seeing something so transformative in an individual life that happened through the court system is very gratifying. That's just one example of, really many where on an individual level, you feel like, wow, the court system and its participants, including me, made a difference for this person's life.
And you've made a difference for our audience and for me because of the understanding you have given us of such a vitally important piece of our lives. All of us at different points are affected by what you do. I'm curious, what has being a judge taught Justice Grover about Justice Grover?
You just are confronted with so much humanity in every case that you really have to come away with an appreciation for just human nature, seeing everyone's positives and negatives, seeing human frailties, seeing people's triumphs and mistakes, seeing all of that played out in court really has given me a lot of tolerance and expectations around human nature. I see that in the people that I'm dealing with in court. I see it in myself too. I'm grateful to have had that glimpse and that exposure for all these years. And that's what I take away.
And we want to thank you for this glimpse. You have opened the door to aspects of our legal system that I certainly have not thought about, and perhaps a lot of our listeners have not thought about, and that's the human element that goes into making it work, and how important a foundation it is as part of our democratic system, where people have the opportunity to get fair representation under the law. I will never listen to views on our legal system again without thinking of many of the things you have said to us. Thank you for joining us. Through your words, a very important illumination of our justice system.
Thank you so much, and for the opportunity and for being able to share this with everyone.
Good day, Justice Adrienne Grover. There you have it, dear listeners, the second episode in our Citizen Arts series, In Their Words, What Public Officials Do for Us. We hope you found this chat with Justice Adrienne Grover enlightening, and you'll join us for upcoming episodes with the likes of mayors, state reps, district attorneys, medical examiners, tax collectors, and more. At Citizen Arts, we're dedicated to presenting information, analysis, and constructive opinion about matters of civic importance. We're a not-for-profit 501c3 organization, and your interest and support of our work are greatly appreciated. On behalf of Justice Grover and my Citizen Arts colleagues, a heartfelt thanks for tuning in. We invite you to join the conversation. Please visit citizenartscreative.org and let us know what you think.